How many times do we need to remind HCS what constitutes cheating? Asks SC. The Supreme Court recently expressed anguish by asking as to how many times do the high courts need to be reminded of the constituents of the offense of cheating. The SC said that there has to be something more than prima facie on record to indicate that the intention of the accused was to cheat the complainant right from the inception. A bench of Justices J.B. Purdiwala and R. Mahadevan took a strong exception to an Allahabad High Court's order of March 7, which directed petitioner Shailesh Kumar Singh alias Shailesh R. Singh, who sought quashing of a first information report FIR, to go for mediation and simultaneously also ordered him to hand over a demand draft of Rs 25,00,000 for the purpose of mediation to the original complainant. Holding that the plain reading of the FIR does not disclose any element of criminality, the bench said, "We are quite disturbed by the manner in which the High Court has passed the impugned order." The court noted the High Court first directed the appellant to pay Rs 25,00,000 to the respondent number 4 and thereafter directed him to appear before the Mediation and Conciliation Center for the purpose of settlement. That's not what is expected of a High Court to do in a writ petition filed under Article 226 of the Constitution or a miscellaneous application filed under Section 482 of the Code of Criminal Procedure, 1973 for quashing of FIR or any other criminal proceedings, the bench said. What is expected of the High Court is to look into the averments and the allegations leveled in the FIR along with the other material on record, if any, the bench added. The High Court seems to have forgotten the well-settled principles as enunciated in the decision of this court in the state of Haryana Others vs. Bajan Lal Others reported in 1992, the bench said. In its order, the court pointed out, it called upon the counsel appearing for the respondent number 4 to make it understand in what manner the FIR discloses commission of a cognizable offence. We also called upon the counsel to make us understand in what manner his client could be said to have been cheated so as to constitute the offence of cheating. What we have been able to understand is that there is an oral agreement between the parties, the bench said. The respondent number 4 might have parted with some money in accordance with the oral agreement and it may be that the appellant herein owes a particular amount to be paid to the respondent number 4. However, the question is whether prima facie any offence of cheating could be said to have been committed by the appellant, the bench asked. Having gone through the facts of the matter, the bench pointed out, the entire case is squarely covered by a recent pronouncement of this court in the case of Delhi Race Club 1940 Limited vs. State of Uttar Pradesh reported in 2024. In the said decision, the entire law as to what constitutes cheating and criminal breach of trust respectively has been exhaustively explained. The court noted, it appears that this very decision was relied upon by the counsel appearing for the petitioner before the High Court. However, instead of looking into the matter on its own merits, the High Court thought fit to direct the petitioner to go for mediation and that too by making payment of Rs 25,00,000 to the fourth respondent as a condition precedent, the bench said. We fail to understand why the High Court should undertake such exercise, the bench asked. The court emphasized the High Court may either allow the petition saying that no offence is disclosed or may reject the petition saying that no case for quashing is made out. Why should the High Court make an attempt to help the complainant to recover the amount due and payable by the accused? It is for the civil court or commercial court as the case may be to look into in a suit that may be filed for recovery of money or in any other proceedings, be it under the Arbitration Act, 1996 or under the provisions of the IB Code, 2016, the bench said. The court asked as to why the High Court was not able to understand that the entire dispute between the parties is of a civil nature. The bench said it also inquired with the counsel appearing for the respondent number 4 whether his client has filed any civil suit or has initiated any other proceedings for recovery of the money. It appears that no civil suit has been filed for recovery of money till this date. Money cannot be recovered, more particularly, in a civil dispute between the parties by filing a first information report and seeking the help of the police. This amounts to abuse of process of law, the bench underscored. The court said it could have said many things but it refrained from observing anything further. If the respondent number 4 has to recover a particular amount, he may file a civil suit or seek any other appropriate remedy available to him in law. He cannot be permitted to take recourse of criminal proceedings, The court held. Swipe left for next video. The court quashed the impugned FIR and clarified that it shall be open for the respondent number 4 to avail appropriate legal remedy before the appropriate forum in accordance with law for the recovery of the alleged amount due and payable to him. The first information report was registered on January 9 under Section 60B, 3162 and 3182 of BNS, 2023, with P.S. Hariparwat, District Agra. The petitioner submitted that he is a co-founder and production head of Ms. Karma Media and Entertainment LLP, which is primarily engaged in production of motion picture. The respondent number 4 informant is running the business under the name and style of Ms. Polaroid Media, which is engaged in the business of financing, co-production, and co-financing media projects. He claimed the informant has lodged the impugned FIR by dragging a civil dispute enters the parties into criminal case. Latest blogs.